Wait till this starts. Okay.
Recording in progress.
All right, so this is LAWS 13013, Legal Professional Conduct, Week 1, Accountability and Responsibility. And we're looking at tutorial problems 1 to 6. And just to note there, if you don't want to be recorded, just turn off your camera, because I tend to put these things on YouTube so that they're accessible to other students rather than using Echo 360, because I'll put them up tonight and I'll find it more efficient. And you'll be able to access directly to those recordings through Moodle. Okay. All right. So, okay, I've just stopped sharing that. Seems to be a little bit slow. So are you hearing me okay? Okay. All right. So it's still broken up?
Much better.
Much better.
Much better, yeah.
Yeah, no, it was because I had the VPN. I was connected into the university systems. That was, I think, what's causing that. Okay. All right. Well, let's firstly, I just wanted to emphasize the importance of this particular subject. A lot of people think, okay, the ethics subject is, not that important. We've been studying all of these substantive law units all of these years, and a couple of procedural units, evidence and civil procedure. And then you come across this unit. This is one of the more important, if not the most important unit you ever do, because this unit gives you all of the rules and professional responsibilities that you need to abide by. And if you breach some of these rules, it can actually terminate your career. So it's really important to understand what your obligations are, whether you become a solicitor or a barrister, or even whether you work in an accountancy firm and are relying on legal professional privilege. There's all sorts of rules and obligations that you have to comply with, and breaching them can have some dire consequences. So don't ignore the value of this particular subject for you practically. Okay, but you'll see that as we go along. So let's have a look at the 6 problems we've got tonight. The first one asks you to discuss or talk about why are lawyers seen as professionals and business people aren't. Although I'm sure the accountants would regard themselves as professionals, so that we'll leave that aside for 1 minute. What makes someone a member of a profession? What is it that makes someone a member of a profession?
Well, they have to join the profession, and whatever the rules are and the money.
Okay, so you're joining a group of people, but you could be a businessman and join a chamber of commerce. That doesn't make you a professional. There's more to it
Based
than
on
that.
training, skill, and education.
Okay, there's training, skill, and education attached to it. True. What else?
Competency testing.
There is. I mean, to get into the profession, you've got to satisfy the priestly 11, which is the knowledge elements, and you've got to do your GDLP, which covers the skills components. And then when you get into the actual profession, you get trained, and you have to keep up with professional development and a point system as well. So there is that continuing training. What else?
You need to have a strong code of conduct, which is exactly what this unit is about, Stephen.
That's right. There is a strong code of conduct. And where's that reflected? Where do we find those codes of conduct?
The solicitors' conduct rules.
Okay, there are solicitors' conduct rules. There's the Legal Profession Act. Okay, there's a set of barristers' conduct rules as well.
And the Queensland Law Society.
The Queensland Law Society has membership requirements, but they only really govern your membership of their society. Whereas for a lawyer, when you get admitted, you're admitted to a Supreme Court, and you can also get admitted, of course, to the High Court as well. Most of you will do both of those things when you get to that point. So let's keep it simple at this point. They're the basic sources of the rules, and you'll need to become really familiar with those rules. Okay. All right. There's a couple of theories, isn't there? If you've done your reading this week, you would have seen that there's two theories. There's a trait theory, and there's also a power and resources theory. So what's the first, the trait theory? What's that about? You know, all these academics who write about ethical stuff, they like to come up with theories and different things. So what's that theory about?
They've got the 6 sort of characteristics, I think you can call it.
Okay, and we've actually mentioned quite a few of them so far, haven't we? So, you know,
wasn't it Millison who mentioned those 6 traits?
yes, but it's not just academics, but it's also judges. And if you look at Chief Justice Brennan, he set out a lot of them as well. So he was talking about legal competence in a high degree, service to the community, professional commitment, personal integrity. And if you even look at some of the comments by Justice Kirby, he goes even so far to say law is not a business, although I suspect some law firms may disagree with that. But, you know, the traditional way of looking at it is that when you're in a profession, you're not in a business. So it's not all about money. But then again, when you look at law firms, they do really run to make a profit. So it's interesting trying to balance those competing objectives. But you do see things like pro bono work. So that's part of being a profession, is giving services for free for those who can't afford them. So there's quite a lot of firms, if not all firms, actually engage in pro bono work to a certain degree. But the skills, the actual trait theory rather, is about things like, as we've said, public service, ethical standards, having an organisation, and intellectual skill based on training. That's what that's sort of all about. What's the other theory? Power and resource theory. Anybody know?
Utility theory?
Yeah, so can you expand on that a little bit?
Using the power and resources in the interests of the public as a whole, rather than the individual interests.
That's right. One of the things about the legal profession is that it has quite significant impacts in a lot of areas. A lot of politicians are lawyers, of course. So you've got a great influence in relation to the political sphere. You've also got the judiciary, another branch of government, which is all about interpreting the law and hearing cases. And then you've got the profession itself, which has a monopoly in a lot of areas. For example, in Queensland, it's you've got conveyancing. In New South Wales, you don't have that monopoly for lawyers in conveyancing. But in a lot of areas, to be able to give leverage that, there are penalties for doing that. So it is a form of monopoly rights over who has the ability to give legal advice. Because that's under challenge now, isn't it, in a number of ways. So you're starting to see, for example, LegalZoom and those sort of organisations that produce legal documents and sell them. AI is going to be a big challenge, as we'll start to see tonight. There's always pressure on this monopoly, because with a monopoly comes the ability to charge higher fees, although there is competition within the legal profession itself around fees. Okay, I think that's enough to get the general gist of why the law is perceived as a profession rather than a business as such. Okay. Oh, by the way, what I'll do is I'll upload some more detailed answers about all of this, so you'll be able, in written form, so you'll be able to get that as well. So I'll do that later tonight. All right. So any questions about any of that so far? Are we all happy? Okay. All right. So the second problem is trying to classify particular types of situations according to whether they're etiquette, courtesy, morality, breach of ethics, or something else. Okay. So what we could do to begin with, I think, is get some ideas on the differences between morals and ethics. So what's a moral? Let's start with that. Anybody know what a moral is?
Well, something that you learn, from your childhood and family and society.
Okay, so it's a convention or it's a convention of a social group, basically. A custom or convention. All right, what's a value?
That also could be, something in the community, but it tends to be more individualistic in the fact that it's a value that you believe in.
Yeah, so it's something worthy or desirable that you have a belief in. Okay, what's a belief? What's a belief then?
The acceptance of an idea that an idea or a statement is a fact or it's true.
Yes, that's right. And what's a convention?
Unwritten rules.
Unwritten rules and practices. Yeah. So it's just coming to grips with some of this terminology before we have a look at these examples. What's professional ethics? Do you think that is?
A little subcategory of ethics.
It's a subcategory of ethics, but it's a category based on a professional group, such as lawyers, for example. Okay. And ethics is a much broader concept. So it's I think one definition of it is the rules of conduct and morals or values, the rules of individual conduct generally. So let's have a look at some of these examples and see if we can try and get some concrete picture of what some of these things are. So a senior counsel carrying a red book bag. Okay. I suppose I could ask, why on earth would they be carrying a red book bag? Anybody know?
Well, it could be their lunch.
Could be. That isn't. And when I say a red book bag, I'm making a distinction between the red book bag and the blue book bag, even more mysterious. This is a really historical concept. Senior counsel, so they used to be QCs, they're now KCs, have red book bags. It's a traditional sort of thing they carry, or they get somebody else to carry for them. A junior counsel carries a blue one. So it's just like a uniform. It's a bandage or a uniform. So what do you think that is? Is it etiquette, courtesy, morality, a breach of ethics?
Sounds like a breach of etiquette to me.
It's etiquette. Yeah, it's pure etiquette. It's an historical etiquette situation. Okay, and the law
And
is...
see, when I read that originally, I thought that was neither, because I mean, if you think about it today, there's lots of lawyers out there that like to colour coordinate. I'm speaking primarily from a female perspective, but like to colour coordinate their outfits and all that sort of thing. So not knowing the history of that, yeah, I found it quite a controversial sort of question.
Well, there's all sorts of funny things about barristers, capes or their regard as well, with little bits that hang off them that people are supposed to pull and deposit coins into. There's a whole history on all these sorts of things. But they're just, more important in the past than they are now. Okay, what about the next one? Arguing with a judge over the admissibility or otherwise of evidence. Now, when we say arguing, this is not just making your submission. This is having a full-on argument with the judge and telling them that they're wrong. And so what do you think that might be?
Breach of ethics.
That's certainly getting into the territory of a breach of ethics. That's right, because the whole idea is that the judge gives the ruling on the admissibility of evidence. You can make submissions, but you can't then start arguing with them and say, no, that's not right. Make your decision again. If you want to do that, you go on appeal. You don't argue with them in court. Otherwise, it is a breach of ethics. Okay, all right. What about the next one? Using your experience to outwit an inexperienced opponent. What do you think of that?
Ethics as well.
Is it ethics or does it depend?
I mean, it depends. The main thing is to always think of justice. You can't
Wouldn't that
Yes.
breach courtesy?
I think you're all so moral here. It's terrible. Why can't you use your experience? I mean, people are paying you to argue a case on their behalf. It's an adversarial system. Okay.
So you've got a leg up, go for it.
This is why people hire King's Counsel or Queen's Counsel, because they've got that experience. So they're hoping that they're going to have someone who can argue in a way that's better than their opponent's counsel. That's why they do it. So it's not really a breach of ethics, but there are some little situations where it can be problematic, and that's really in relation to criminal law. Because if you're a Crown prosecutor, you've actually got this added burden. So if, for example, the other side doesn't raise an argument that they should have, then there is an obligation to raise it. So there's some differences on the criminal side, but on the civil side, no, it's not a breach of anything. I don't think it fits into the scheme at all. It's just the reality of life. You hopefully pay for what you get. And that's, no. Anyway, it's good to see you have some morals, so well work those out of you. Only joking. All right. What about failing to pay a parking ticket? What do you think about that?
Well, it's morals.
Yeah,
And-
it's a moral issue, isn't it?
Yeah.
It's not courtesy. It's not a breach of ethics, etiquette. If you had 500 of these, I mean, there was a barrister who had chambers in Brisbane next, the Inns of Court next to the freeway, and used to park on the side of the road next to the freeway on the and it ran up hundreds and hundreds
in the
of
traffic island in the middle.
the traffic island. Yeah, so that sort of got to the situation where it was starting to look like it was disregard to the law of the law. But
If this can stop you from getting admitted, I got no chance because I've probably got hundreds of parking tickets over my time as well. Back in the day, they were $30, so I was like, it's cheaper than paying for parking. I'll just pay the parking fine.
No. We'll look at all of those suitability matters. No, that's not one that's going to cause you any grief. But we'll get to all of that. Okay, what's the next one? Failing to attend scheduled appointments with clients. What do you think about that?
Courtesy.
It is courtesy, but
Hari
depends how often you do it. You know, if you do that all the time, then it's going to get to a breach of ethics situation. Failing to do it once, that's a courtesy issue. But if that's a repeated behaviour, then it gets towards the breach of ethics. Same with the next one, failing to attend scheduled appointments with practitioners. It's the same answer for that one as well. It depends on the frequency of it. All right, ignoring clients' repeated requests for information and updates about their case. What do you think about that one?
Yeah, breach of courtesy.
No, it's more than that, because you've got an obligation to inform your client about their case and stuff. They're trying to, ask you questions about it and you're ignoring them. You're actually breaching your duties to the client.
I had ethical and etiquette there.
So why did you say etiquette?
I went etiquette because at the end of the day, I think it probably comes back to a bit of that. I tie etiquette in with profession. And for me, that's of a high standard, which probably shouldn't be there. So the etiquette towards another individual is something that I feel needs to be there. And I'm talking around in circles now. But yeah, it's our firm prides that. It needs to be one where you need to be showing that professionalism. And I sort of put that in under that etiquette banner.
Yeah, I mean, you're really judged by your actions, aren't you? So other firms and other practitioners are going to judge you and they see how you interact with them. But I mean, this one, if that keeps happening, then it's an ethical issue. as well. And in terms of the consequences of these things, breach of etiquette, you may get a bad reputation if you repeatedly do that over time. Breach of ethics, if it's bad enough, can lead to professional misconduct, which has much more serious consequences. Courtesy, well, if you don't do that, people will begin to think you're rude. Again, it's a reflection on your personality and how you deal with others. It's not necessarily going to have, professional consequences in terms of like you would have with breach of ethics. Morality, again, not as serious as a breach of ethics in terms of your professional life. I suppose it depends what you did, but breach of ethics certainly has the highest consequences, I think, out of most of these things. All right, what about a lawyer convicted of manslaughter for killing a pedestrian with a car while drink driving? What do you think about that one? Because there's a case fairly similar to that, which we'll look at tonight. What do you think?
More like a morality and your ethics as like a lawyer, I suppose. But like drink driving is kind of like a morality for like everybody, not just lawyers, I suppose.
There's a case called Zymes, which we'll look at a little bit later tonight. And that was a case where similar to this, where a lawyer was drunk and killed, it was a manslaughter case and actually killed a motorcyclist. And they were disbarred whilst they were in jail for the 2-year period that they were sentenced. And there's some comments by the High Court on whether this should amount to a breach of ethics or not. So we'll look at that a little bit later. But I think it will fall into this category of breach of ethics, as we'll have a look. But we'll look at the Zymes case in particular a little bit later tonight. Okay, ignoring a law student's request for an interview. That's a bit rude. What do you think about that?
Well, it's courtesy.
It's courtesy. Yeah, it's courtesy, isn't it? And then you've got a lawyer campaigning to make euthanasia legal. That's a moral issue.
Moral issue, yeah.
And that's a moral issue. Okay. There is some cases around suitability for admission about people participating in demonstrations, which we'll look at in subsequent weeks, and you'll start to see the impacts of those sorts of things. Okay, all right. So there's some categories of things there. The thing about ethical problems is you need to be familiar with all these rules because they arise all the time, and they arise at the most inconvenient times. So you really need to have a good grip of these things because it really determines what action you take. And if you're really stuck, you can ask senior counsellors on the Law Society for their advice on what you should do. Because you'll come across situations, for example, where a colleague will want you to backdate a document or say you've signed something when you haven't. All sorts of things happen in practice. So you need to be really wary of those things.
Sorry, Stephen, if I am jumping ahead, and we'll get into it in the later weeks. But with, for example, the euthanasia question, like if you're protesting or campaigning for something that is within a phrase, like, I mean, we have a right to protest and, you know, that sort of thing. Like, can you not have an opinion if you're a lawyer? Like, you're still a human. Like, as long as you're doing it within the correct framework, is that not okay? Like, that's
fine. A lot of these cases are historical. So we had people who would, for example, lawyers who were participating in demonstrations in support of communism. And you've got to look at the time frame of when these cases happened. So, and also the extent to which the demonstration goes in terms of whether they're actually breaching the law by damaging property. And there's other aspects to it, but a pure demonstration, arguably something, even if it had a police permit and all the rest of it, that would be fine. That's not going to be a problem. Where the problems arise is when you start to have property damage, people being injured, those sorts of situations, then it starts to get a bit more problematic. But we'll look at all of that. We'll look at it in the category of suitability for admission. So there's a whole pile of stuff around that. And I don't want to get too far ahead with us. We've got enough to do tonight. All right. Problem 3, research the arguments for and against whether there are too many law graduates in Australia. Okay, well, what do you think about that? Are there too many law graduates?
Yes.
Okay, and why do you say that?
There was a study done in 2014, I think, and they said there are quite a few law graduates and not enough jobs out there and all sorts of stuff, right? So I think I was talking to a lawyer today for my placement doing practicum. They reckon that the last 2 years, a lot of lawyers have been grabbed, so there is a bit of need. I mean, they're looking for grads and stuff like that, but going back before, I mean, there were more and more students coming out, and most unis had law schools and all sorts of stuff, so yeah.
Well, I can tell you, you'll be glad to know that I had a look at the graduate survey that's put out to all graduates who finish degrees. So I had a look at the law degree one. And what we had for CQU law students, the latest figures was that 78% of law students were in full-time employment within 4 months, and the other 22 were in part-time employment within 4 months. So that's pretty much 100%. And then the national average was 67% and 30% respectively. So we do better than the national averages. So in terms of employment, it's quite good.
So what are the factors for those figures?
Now, where a lot of these, those figures I just mentioned, are surveys sent out to graduates about 4 months or so after they've graduated, and it asks some questions whether they're employed or not. It doesn't give you a breakdown of where they're employed or anything. It just gives you an overall.
When was the survey done, Stephen?
It's done all the time. It's a federal survey. It's done by the Commonwealth Government on absolutely every degree in Australia. When they send it out, I don't know which, those figures there, I think, were for 2022, 2021, 22. There's always a little bit of a lag. Obviously, there's none for 23 because no one's graduated. So, yeah. But where a lot of this came from is that there was an article by the Australian Financial Review, and it was done, just see if I can see, if I noted down when it was done. It was a few years back now. 2015. And it published an article that said that there were 14,600 law graduates coming out into the profession. And the profession at that time was 66,000. The trouble with that particular report, which was picked up everywhere, is that it double counted. It counted all the graduates from law degrees, and it added to that all of the graduates from GDLP. So it actually doubled the number. So there was this great furor that all of these law students were coming into the profession and there were no jobs for them. But they, in fact, had all of the numbers. They were wrong. So what happened was that the Australian law deans got together and added up all of the numbers. And the most recent, I'm just having a look, the most recent figures in 2015, it's probably a later one now, but there were 7,500 graduates. Okay. But as you can see from the percentage figures, people are getting readily employed, and those percentages are a lot higher than in most other disciplines. So people get, as lawyers, they get jobs in law firms, they get jobs in accountancy firms, government, business. So in terms of your prospects when you finish, they're quite good.
There's quite a lot in construction as well, because I work in construction, and
Yeah.
I recently hired a cadet who's doing law degree, working as a contracts administrator. So I've seen, though some of them, they do not have a practicing license, they wouldn't go for that, but they still have a bachelor's degree in law, and they are working within the commercial space in construction.
Yeah. There's a lot of opportunities.
Yeah.
I mean, what my advice
You
to
find
everybody,
cheaper labor, Stephen. You could not find cheaper labor which is qualified, mate. Yeah. So they Seriously, there's ethics issue there. Yeah, $50,000 to $60,000 for a law grad, and a dishwasher makes more money than us.
Yeah.
Stephen, I found an interesting article from New South Wales Chief Justice Tom Bathurst that was talking more about the AI and how we're, you know, the potential for not only paperless courts, but paperless people. So that was quite an interesting article as well. Yes, I used to be on the Legal Practitioners Admission Board in New South Wales for many years, like about 9 years. So I know Chief Justice Bathurst, but it's AI is an interesting area, and we'll talk a bit about it throughout the course. But it's one of those areas. Well, let's wait until we get to that question, because it's got some interesting things in it. But I think just generally for this, your prospects are quite good, particularly in rural and regional areas, even more so. Because what I find, we regularly get requests from law firms for people to start even before they've completed their law degrees. And that's another thing you should bear in mind. If you get those opportunities, and you can try and get like a part-time position in a law firm, if you can manage that. Of course, not everybody can, but if you do, it does help you in terms of getting positions. Any sort of experience you can get, even volunteering at a community legal centre, all of those sorts of things are really important if you can manage it. It'll help you a lot with your job applications. So just mention that. And I can say that with all truth and honesty, because I went to a meeting with the Queensland Law Society, and they've just done a massive survey of 1,300 different law practices in Queensland. And that was one of the things that came out when they were looking for graduates. They were looking for people who had some sort of part-time experience with the law. So if you can get one of those opportunities, take it. Even if it's inconvenient, it'll help you. Okay, all right. So there are a lot of law graduates, but there are also a lot of jobs. Okay, we'll keep going. Question 4. Now, this is where the ChatGPT thing starts. So here we've got a question about medical practitioners, and they've got a set of rules. And then you've got lawyers who have a set of, or the sort of absence of a specific rule in relation to sexual conduct relationships with clients. So what's the position with the medical profession? What do their rules require?
Well, they've got things regarding the sexual harassment sort of stuff, those sort of things.
Yeah, so they've got a specific rule saying that that's totally unacceptable and you shouldn't be doing it. Okay, is there such a rule for lawyers in Australia?
No.
No. Is there such a rule for lawyers in New Zealand?
I have no idea.
Yes, there is. Is there a rule against that in most, if not all of the US jurisdictions, actually? Yes. So Australia is a little bit out of sync with a lot of the other countries in the world in respect of this. Yeah, go on.
Sorry, Stephen. When I was reading up on that, I found that actually quite intriguing, the fact that we are so, I guess, backward in regard to that in Australia. Is there a reason why they decided not to go down that path and align ourselves with everyone else?
I don't think there is any stated reason anywhere. I mean, it can be caught under some of the other rules, but realistically, we should have a rule, and it's long overdue, but it's just not happened.
Well, the Fair Work Act has just introduced, sexual harassment rules.
Yes, that's right. I mean, it is caught by other areas, but there's no specific professional rule for lawyers, which is a bit disappointing in some ways, but it's never been addressed in any of the jurisdictions so far. How do you think it could be caught under the rules that we do have?
A breach of conflict, like it's a conflict of interest.
It's potentially a conflict of interest, yes.
Ethical.
You may not be acting in the best interest of your client.
Well,
I think in that case, it was shown that she didn't give him proper, like she wasn't acting in his best interest. Like he didn't get his like legally, like his legal phone calls from prison, all of that sort of stuff. So like if you're boxed into that kind of corner, like you actually can't represent your client properly.
No, that's Morell's case.
Yeah,
that's right. And it was regarded as unprofessional conduct. It went a little bit, that one went a little bit further because there was inappropriate disclosure of information, not representing the client properly, potential loss of legal professional privilege. There was a whole lot of nasty twists to that case. And it's worth reading it. I've got the link to that case for you to have a look at. It's worth reading it. But generally, you want to avoid these situations and not find yourself in this sort of tug of war situation between your emotions with somebody and then your professional career. It's better to keep it completely separate, then you don't have any of these issues.
In a practical sense, Stephen, how does it work with, if there was a rule, you acting for someone that you have a pre-existing relationship with? Like, is it different if you were already married or a girlfriend?
Well,
or
there's a good old saying: if you're acting for somebody like that, you've got a fool for a client. Basically, you really should have separate legal advice. I know that entails, if you're married to somebody, even you sort of feel, or somebody in your family have this natural, you want to help them. But the reality is, it's better if they're separately advised. And of course, your family never understand that. They never understand that because they perceive you. You're the lawyer. You can tell us what the answer is. Why would I want to go to somewhere else? But yeah, it's a dangerous sort of thing. It's like doctors. They're not supposed to. Well, they're not supposed. They're ethically prevented, except in emergency type situations, to treat their own family. So same sort of thing. There's attempts to just separate the professional from the personal because you get all of these conflicts of interest, and it's far better to keep it all separate.
Even friends can push that boundary with you being a lawyer. That's right.
Absolutely. And it's really difficult for academic lawyers because they don't have practicing certificates, most of them. So, I mean, it's an easy answer. Oh, I don't have a practicing certificate. I can't advise you on that. But, if you've got friends, then it sort of gets to the point where you say, well, you need to come into the firm and we'll open up a file, that sort of thing. And it's better if someone else represents them. But, yeah, I know it's difficult, but you're going to encounter that if you haven't already. You want to avoid those situations if you can. Okay, all right. Well, let's see what ChatGTP said. So wait a minute, I'll share this screen. Let's make it a little bit bigger. Okay, so I asked ChatGTP. Let's see, share screen. Sorry, I'm talking to myself now. Where are we? So hopefully there we are. So there's the question. Now with ChatGTP, it is really dependent on the clarity by which you ask it questions. So slight tweaks can get different sorts of results. But if you're very specific, you can then enter a conversation. So it's not like Google in the sense if you Google something, it'll give you a list of responses. You can interrogate ChatGTP. So you can see here I asked the question, which was your question. I did tweak it a little bit. I'd said I put in Australian lawyers to see whether it could be a bit more specific and asked it to refer to cases and codes of practice. Now, one of the things it doesn't do is refer to cases. Okay. I think that'll change pretty quickly when that type of information gets entered into its knowledge base. But at the moment, its knowledge base is up to 2021, sometime during 2021. It's in version 3.5. Version 4 is coming out, I believe, in a month or two. It will be 100 times bigger in terms of its databases than the previous version. But just look at its answer here. you see medical practitioners subject to strict rules. That's correct, isn't it? We know that. Okay, and it's mentioned the APRA guidelines. It didn't mention the specific guidelines, but you could probably ask it to be more specific. But it does state, the guidelines state, da-di-da-di-da. All right, so that's fair enough. That's accurate, isn't it, so far? The rationale to prevent the safety and well-being of patients. Then it's contrasting Australian lawyers have codes of conduct and ethical standards. Then it actually talks about Australian solicitors' conduct rules and the Bar Association rules. It doesn't tell you which ones, but it does tell you there are rules. All right, and then it says it doesn't specifically address sexual relationships with clients. That's correct. Subject to debate within the legal profession. Then it says, nevertheless, there have been instances where the profession has taken action, and it gives some examples. You have to be really careful about things because sometimes it makes things up. So that's one of the challenges with this sort of technology. But so far, it's pretty good, isn't it? When you look at it as a if you were a lay person who had no knowledge at all, didn't know where to look up anything, typed in that question, you would get a reasonable answer so far. Okay. So I then asked it, well, which specific rules? Is it going to tell me which specific rules? And you see, it's very polite, isn't it? As I mentioned earlier, these are the rules. So it interpreted that as what are the rules rather than I wanted to know which specific rule within that. So it didn't quite do that, but look what it did here. With the Australian Solicitors' Conduct Rules, it's starting to talk about confidentiality, conflicts of interest. Some of these things aren't quite right. Professional boundaries, that's true, but it's not really a rule. But I think the interesting thing about it is that general standard of its answer is not too bad. I then asked it what are the specific cases and the names. Got a little bit upset with me. It had another little bit I didn't reproduce here saying that it didn't have that in its database. It can't tell me the name. No, I asked it what were the case citations. That's right. And it came back and said it couldn't do that. But if you look at this, what are the specific cases and their names? So it's come up with, and it talks about particular people. So you could probably do searches on those names and would come up with cases in Australia, and if you did a Google search, for example. Then I asked it to expand upon its answer by considering the AMA Code of Ethics 2004. Again, it does a reasonable summary, but it doesn't have the specific rules. So the question is, well, what do you make of that? So if you've seen what the AI came up with. Now, how did that compare, do you think, with the standard of stop sharing, standard of your answer?
Well, in some cases, I've tried it before, like last semester, and it actually came up with better answers than mine.
Yeah, so what implications does that have?
Well, we're talking about, the ethics of it all, isn't it, really?
Professional indemnity,
Well, okay, professional indemnity. Well, it doesn't have professional indemnity. Is it giving legal advice?
no, we are. But, if you were relying on that and you were giving someone advice based on what that said, you'd be.
But it's owned by a corporation. It's owned by OpenAI, that corporation.
When you
So
joined
this is
up,
their product, it is in one sense giving legal advice if you ask it legal questions.
Is there a disclaimer?
It has sorts of disclaimers on it. It says things that if you ask it a specific legal question, it often comes back and says, go and ask your lawyer, but it'll then tell you anyway. And in some areas, it does really well. In areas where there's information in its databases. So it's gone through and trolled through the web. So personal injuries lawyers, for example, those law firms always put up cases and examples. And so all of that information has been hoovered up by this AI. So in some areas like torts, it does really well. Jurisprudence is another area where it does really well. International law is another. In other areas, it's weaker because it doesn't have its database, doesn't have the information in it. So it's patchy about how good it is in different areas. But that's, but I mean, you could argue that it is potentially giving legal advice, which would be a breach of our laws.
I
But
think if you were considering from a self-represented litigant, someone who sees the profession as, you know, greedy and, you know, that we're not to be trusted, etc.,
or it might just simply be they just can't afford it.
that's true too. Yeah. So I mean, from a self-represented litigant, they could quite easily take this and represent themselves in court for something that's on a more simplistic level.
Well, this month it's running its first court case in the US for a traffic violation. So all the arguments will come straight out of the AI. So it'll be interesting to see what it does with that. But if you start to think about this, I mean, what implications does it have for you?
Well, there's a potential for the entry-level jobs to go because a lot of those tasks can be done by a program.
I'd be concerned about where the information's been pulled from, and then have you got any issues in regards to our student integrity in regards to how you would actually transpose that information. One, how reliable is it? And then two, how you use it.
Yeah, so it does have reliability issues. I mean, the actual AI itself, the way it's constructed is that it's just a massive collection of information and it looks for patterns. That's how it works. So that's its sort of thought process, if you could really call it a thought process. So it does inherit the biases underlying the information that are reflected in the information. So they've had to modify and moderate its responses to certain things because it did have, generate problems with sexism and racism and all sorts of things, and they were all moderated. Of course, they also moderate things like giving legal advice because they don't want to be perceived as giving legal advice. But I think the real question here is, what are you value adding as a professional above what something like this, and given that this is at a low level still and it's going to rapidly improve, what value are you adding in your professional life above and beyond what this thing can produce?
Well, knowledge and experience, that's what you'd be adding to it.
It's not necessarily knowledge, because it will have the knowledge of, effectively, it'll have all knowledge.
I think it's a level of personalized service you provide, right? It's the interaction.
Certainly personal service. It can't do personal service, can it? It can't interact well, you know, on a human level. It can interact in terms of asking it questions, and it'll easily get to the stage where you'll be verbally asking it questions, and you'll probably end up having some sort of avatar, have you, answering them as well. But
tailoring as well. We're tailoring it more, and we're not giving them extra stuff that they don't need.
That's right. See, it's prefaced on the basis that it's being asked the right questions. If you don't know how to if you don't know how to ask the right questions, you're going to get all sorts of confusing answers, or answers that aren't actually relevant to your problem. Jurisdiction's a really obvious one. If you just ask it a general question, it will scour the internet and it'll give you, a bit like Google, it'll give you sources from all sorts of jurisdictions. And if you don't know that jurisdiction is an issue, you will think that the law of New South Wales on some particular thing applies in Queensland. And then you rely on that.
Saying that, Stephen, I think, I mean, considering what stage this is in, it's pretty good when you think about it. I mean, I think it will be like Siri in 5 or 10 years when I say, what is the temperature? Siri says to me on iPhone, which city you're talking about, right? So I'm guessing this will get to a point where it will prompt you to narrow down the funnel and ask the right question. But yeah, now, like Emma said as well, and others have said, ours is personalized service, tailor-made, and we're specifically working for your interest rather than just giving you general
Well, it's also those interviewing skills, isn't it? Like actually sitting down with your client and asking those questions that they don't even think of.
That's right. Although you do need to play with this because it is quite good at it's quite good at a number of things. Summarizing vast amounts of information, it's good at. It's very good at, you can ask it to write blogs. It's very good at things like that. Essays, creative things. So it does have a lot of advantages. But I think
I
at the end of the
wonder,
day, yeah, go
sorry,
on.
I wonder if it would, if there's that potential to replace, your good old duty lawyer, like your duty lawyer's there on standby for, those who turn up to court. But, if you've got a computer or, say it's like an ATM machine sitting in court and the self-litigant can go up and, ask all the questions and go into court, the duty lawyer as we know it today might be a thing of the past.
Well, it'll be on your phone. It won't be on a kiosk.
But I think the point comes to asking the right question. And we do that in law units all the time. What is the legal question? And I bet you 20% people don't get it right? Or there's a better way of doing it. Otherwise, everybody will get a HT, right? So
right.
I think it's about asking the right question and then applying the law.
Yeah.
So it will give you, we already have Google. We could put in what we want. It will give us some ideas. But I think it's more around the legal question we're asking and then applying that. What do you think, Stephen?
Yeah, it's also the synthesis, the ability to do research and synthesize information to get the answers. Those sort of skills are still needed. What you'll find, I think, initially is, and this is already happening, some of the large international law firms are developing their own versions of ChatGPT and putting in the information that they have developed about their particular practice areas. And it's used as an aid and an assistant to lawyers that are doing those tasks so that they can get through more work. So these things are already being used. Sorry?
I think for students, it's probably at the moment just taken away the industry of people selling their notes to other students. So it's probably just taking money out of poor students' pockets for right now.
Well,
you don't need to pay for it anymore.
It is interesting. It is actually an academic cheating. So it falls within the definition of an academic cheating service under the TEXA legislation. TEXA has powers to seek a federal court injunction to prevent ISP providers circulating this. It hasn't done that because it's a real dilemma for the regulator because it's got a lot of positive benefits and it's got this sort of negative side as well. And it's also a big challenge to universities when students probably will start using it in assignments and what have you.
Stephen, I can add something too, if okay. It's like when you go into LexisNexis and Westlaw and stuff, if you don't know what to type in, you're not going to bring up the right stuff. So
that's right.
It really brings back to that no lay person can do this, or get the right information unless they know what they're doing. So it's a skill.
It is a skill, but I think it will improve dramatically. So we need to watch the space. But I don't think it'll replace. I don't think there'll be a wholesale destruction of the legal industry. I just think the legal industry will evolve with it, and same with accountancy and other professions as well.
You see on Facebook at the moment that you've actually got people now spreading the word about a bot actually developing their own wills, and to me, you just go, wow, at a really discounted price. You don't need to see a solicitor because this will do it for you.
Yeah. Well, you can go and buy those sort of will kits at the post office. They've been around a long time. They're just newer versions, and in some ways it mightn't be a bad thing. But if you've got a complex will situation, it's most likely not going to be able to deal with that very well. But for the run-of-the-mill, simple sort of stuff, absolutely. And those things are readily available in the US, and they will be here as well. But is it going to replace succession laws? I don't think so.
Maybe we need to be legal programmers.
Well, there's whole careers in that whole space. You should do legal apps unit, although you're about finished, so you'd learn how to program.
Say that legal automation's a good unit.
It is, yeah, and it's going to get better. But anyway, all right, we'll keep going. It's an interesting area. All right, Zymes's case. We've got two problems. We haven't got a lot of time, so just briefly have a read of Zymes's case. It's a high court case. It was a barrister who was convicted of involuntary manslaughter arising out of drink driving, and and the killing of a motorcyclist. There was a 2-year suspension from the bar. But when you have a look at that case, there was no mens rea. There was no intention or to do this. It was seen as an uncharacteristic involuntary act. So it was difficult to find that Zymes was an unfit and improper person. So you need to have a look at what the different judges said, because they split. Different judges went different ways. I mean, the ultimate result was that 3 of them, Fulliger, Kitto and Taylor, thought that the appellant, Zymes, should be suspended from practice during the term of their imprisonment, which in effect they would be anyway because they were in jail, so they couldn't really practice in there unless they were advising their cellmates. Then you had 2 judges, Dixon and McTiernan, dissenting. And, it really comes down to looking at the circumstances of the offence, not just whether there was a conviction or not, because it's really about the character of the particular person as to whether they're fit and proper. Have a read of it and you'll see the various arguments. It's one of those cases that sort of goes in multiple directions. But it is law to the extent that you can have a situation where personal misconduct can amount to a professional sanction. So it is possible. Okay. So that's a bit short on that. You need to read that case and have a look at it. The last one was a bit ironic in some ways. This was, should drink driving convictions affect law students seeking admission to the legal profession as well as practicing lawyers? And there was poor old Justice Howie who fell on his judicial sword, in effect, because he was, he was commonly dealing with drink driving cases, and he was quoted as saying, drink driving amounts to a socially irresponsible behaviour of a very significant degree, having regard to the potential consequences of any driver, etc., etc. The only trouble is that he got convicted of drink driving, high range drink driving. So he had to plead guilty to that, and he got sentenced. So it's an interesting sort of juxtaposition, isn't it? Somebody who's on the bench dealing with these cases then in fact commits that offence. Now, the thing about drink driving, it depends a lot on whether it's low range, mid range, high range. And this is also when you're going for admission, if you've got drink driving offences, what level they were, how long ago they were, whether there's a pattern of them. And if you're towards the higher end and there's a regular pattern of it, then that doesn't go terribly well for admission. You could well end up being delayed on admission for those sorts of things. So be wary of that. One-off drink driving offences probably won't be a problem. If it's attached to killing somebody, then you're in the Zymes case sort of situation. Repeat histories you want to avoid, especially at high levels. Yeah, so just be wary of that.
We deal with a lot of drink driving cases, well, traffic offences as such, within our firm. And there is that very low level drink driving that actually doesn't have any court appearance. So it's just a fine and a suspension and off you go. So how would that be viewed?
Well, when you go for admission, you have to come clean on all of these things, particularly if any conviction has been recorded, probably even if it isn't recorded. So you have to detail all of those things that have happened in your past. One thing that I say to students who are starting their law degree right at orientation is if they have got offences of any type, they should talk to me about that. And because sometimes you want to get a ruling from the legal practitioner's admission board early on as to whether something is going to be a problem. Rather than doing the whole law degree and then discovering it is a problem. But generally, most things will not prevent admission, particularly if they were a long time ago and if it occurred when you were young. So if there's been a long period where there's no repeat offences or you've been a relatively clean skin, if I can put it that way, generally that's okay. They really don't like any offences of dishonesty. So typical ones that law students come up with are, social security, receiving social security payments above what they should have got, and they're not repaying it. So if somebody's received more Centrelink funds, for argument's sake, than they were entitled to, then they should come clean about that and repay the amount. And that is a better situation than Centrelink prosecuting them and then they get that record and then not repaying it. So that's a classic one that frequently occurs. Any offences of dishonesty, stealing of anything is problematic. Yeah, so there's a few admissions coming out there on that chat, but yeah. So I think if you're worried about those things, come and see me, or just email me and have a chat about whatever the circumstances were and see if it's likely to be a problem for you. Most things won't be, but occasionally you get students who've done things like we've had convicted murderers doing our law degree from jail. So there's all sorts of things, all sorts of circumstances happening. So if you've got one of those sort of situations, just let me know and we'll have a look at it and see whether potentially it's problematic. Okay, that's been a bit of a whirlwind tour today. We've had all over the place, but are there any questions generally about anything from week 1? No? I do advise you, sorry, I just want to say, when we get to week 4, when we get to money matters, do a bit of work beforehand. There's a lot in week 4, and we've got an ethics officer from the Law Society going to give you a talk about trust accounting. Stafford Shepherd, really experienced practitioner, and basically he's in charge of all of the trust account audits and all of that sort of area, the ethics area. So that will lead into our time for tutorials that week. So you need to spend a bit of time in week 4 because it's got a lot of content, including learning how to do basic trust accounting, which you need to have a reasonable knowledge of. That's one of the areas that the survey of law firms came back on as saying there was not a very good knowledge of trust accounting. And you do that at PLT, but we do it here and do some of the accounting as well so that you get a better understanding of that. I know you're probably saying, I did law, I didn't do accountancy. But you do need to understand how the trust account works. And that's particularly important because that is one of the areas where a lot of solicitors come to grief, is failing to manage that trust account properly. And, they end up being struck off because it again comes down to managing clients' money and not doing it properly is really frowned upon. So, okay, any questions?
Stephen?
Yep.
Some of those rules and regulations and the Legal Profession Act 2007, should we just, should actually be reading them all, or is it
you will go through pretty much most of them in this unit, and you do
Okay.
need to be familiar with them. Let's face it, if you don't know the rules, you're not going to recognize a problem when it happens in practice. And then you're going to react without knowledge of the rules and do something which may not be the best solution. So you really need to come to grips with these rules. Because, as I said earlier, it just happens out of the blue. Somebody will ask you to, and I've had this happen to me. I was asked once to backdate a document by another solicitor in a large law firm. I refused to do it. These things happen and you've got to be careful. And this pressure, if you've got a partner asking you to do that, it's a really difficult sort of situation. Because at the end of the day, it's your career and you've got to manage it properly. But you need to understand these rules so that you recognize situations where there's a problem and you avoid the problem. Or if you don't know the solution, at least you recognize there's a problem and you can ask somebody. And that's really the main thing to get out of this course. I sort of see this course as almost a form of insurance. You know, you've got to know the situations to avoid them. But you'll see a lot of them in this course, and that's why it's valuable. Okay, any other questions? We've gone over for 5 minutes. That's not too bad. Okay. All right, look, I look forward to seeing you next week. And play around with ChatGTP if you can get yourself a license to use it. It's well worth experimenting with.
Yes, but that's the ChatGPT is a new thing. So, you know, because Bing and Google and
well, they're incorporating it into Bing. Microsoft putting it in Bing.
Yeah, but they're making their own as well. So there'll be a lot of products, you know, coming in the next couple of years.
Yes, that's right. And it's not just written stuff. It's also art and visual stuff as well. So you can combine the bots together. So you can get ChatGTP to talk to DALL-E to produce artworks and all sorts of things. So they can work in conjunction as well. But anyway, enough of that. The future will come soon enough, as they say. All right, I'll see you next week. And I'll put up the recording tonight, as well as a more extensive answer guides on all of this stuff, so that you've got access to that as well. Okay, and it'll be under the weekly topics in the Moodle site. Okay, that's where you'll find it. All right then. Bye for now.
Thank you, Stephen.
No worries.
Thanks, Stephen.
I'll see you next week.